and then they got you to get
schemes to protect crooked police, judges, and those who set up these false allegations against them. Why did they falsely accuse someone, angry spouses during or after divorce, to gain custody of children? Others for monetary gain, and those who just want to hurt someone. This crime against the innocent gets overlooked because there are so many true criminals that do commit these acts against others. What is there to do when a jury sits and listens to half the story, sees a signed confession because an accused person is scared, uneducated in the devices used in interrogation, and just wants to cooperate with the police, as we all been taught to do if you're any decent person? I've seen firsthand people wrongfully convicted of crimes they did not commit. What does this do to them and their families? I can expand, but I need to be concise. A person sits in a jail cell. His or her calls are listened to, shortened. Food is less than you would feed a dog. They sleep on steel beds with a stranger that may be a real derelict. If you're a true convict, maybe this wouldn't bother you. But would you want your sweet son or daughter, mom or dad, relative that you love so much to have to be put in a compromising situation of danger, depression, and hopelessness? They lose their jobs at home, lose their reputation, because even if it's overturned, there are always those who say, maybe they did do it. How does this happen? The justice system. It used to be based on the burden of proof, or you were innocent until proven guilty. Now the police coerce the accused to confess with their forceful techniques and threats. The lawyers convince the accused to plea bargain, pleading guilty too for a lesser sentence, even when they're innocent. The judges have the authority to pick and choose that which will be used as evidence exhibits. They cover up the truth, suppress it from the jury so that the jury only sees bits and pieces of what they need to decide the fate of someone's life. Where there was supposed to be an interview of those who served on the jury, there are people that sometimes know the accused before they are biased. There are deals between judges and lawyers. It's not about truth anymore. If someone says they are innocent and there's valid evidence to prove it, all should be submitted to the jury for review. I've watched families miss once-in-a-lifetime events due to electronic monitoring or
Chief Justice Chase Rogers, and committee members, I, Joanne Lenardi, former owner and operator of Joanne's Kids Family Daycare, stand before you, a victim of the system we are here today to discuss. My innocent son, Frank, was wrongfully of the Norfolk Police Department because he failed to investigate anything. Not even the families that attended my daycare. He took the easy way out by coercing a confession from an 18-year-old with a processing and speech delay disability that prevented him from understanding his Miranda rights. They wouldn't acknowledge that he was in special needs at the file from school.
Essentially, my life has been consumed with litigation, defending myself and my family against retaliation by the court. I'll give you a document about 10 pages long that illustrate about half of the issues. I guess the main problem that I see is that there's no accountability for judges in the judicial branch. There's no accountability for family relations officers. It's even difficult to state prosecutors. And that judges often will work with the prosecutors to settle a case. My initial introduction to the family court was, to the court was through the family court. My children were taken away from me, not for any abuse, but what I see is bias and discrimination against a person with disability. I have attention deficit disorder, and the judge based his ruling in part on my disability, why he gave sole custody to the mother. We ended our divorce with equality, joint custody, shared parenting, and a couple days later the mother filed for sole custody, no changes in circumstances, and the judge gave it to him. Against every recommendation, the mother at the time was on trial for stabbing me and had a protective order in place that she continued to violate. And I don't understand how the court could do that. But this is Rockville Court. I'm hearing, it sounds like a theme here tonight. I wasn't allowed counsel. I told the judge that I talked to the Judicial Review Council that I was entitled to an attorney for a contempt motion. And Judge Graziani's response was too bad. I saw bias against fathers, being held to varying incomes, just what I saw as a pattern of abuse in the family court, and not just by this judge, but judges in general. There's a consistent bias against fathers in family court, and there is no accountability to the judges, and there's very little laws, and so the judge is free to do what he wants. Judge Carroll was my worst experience. He granted a restraining order against me with regards to my son, claiming I committed a violent, aggressive act based on an argument with my son. He went into my family, my Irish history, my religion. He said he had a case of a father just like me, and I was going to end up the same way as him. My parents were stupid. He admitted to calling prosecutors in a pending case. I had a pending case in Enfield, and he admits to calling the state prosecutor and telling him not to deny the case. I mean, how can a judge do that? This is the head of Rockville Court. He said that he's assuming that I'm guilty of a crime. I should be arrested. He asked where I lived. He said, well, the state police will take care of it because of where I live. He admitted to meeting with family relations, meeting with the other attorney, meeting with counsel privately. I mean, I thought that ex parte communication wasn't allowed, but apparently with Rockville it's okay. And then the restraining order included the mother because of a computer error, which he refused to fix. It was brought to his attention by the clerk. And he said, well, that's a computer problem. We can't get to it now, so I'm not going to do anything about it. And then what he did is he took that document, knowing it was false, drove it down to Hartford Court, and gave it to the state prosecutor, telling them to have me arrested. And that was put into an arrest warrant affidavit and used to have me arrested. So here you have a judge committing a felony. I mean, the head of Rockville Court committing a felony by knowingly submitting false documents in an arrest warrant affidavit. And so I was arrested. The judge filed a complaint, and he issued a second restraining order against me, taking away my daughters. There was no allegation of abuse. There was no children even listed. I walked into court and asked why I'm being restrained, or who am I being restrained from? And he said, well, that's what the trial, or that's what the hearing will decide. Well, how did they take away my kids if he doesn't even know? And so, on and on. Judge Clazak, meeting with family relations, calling the criminal courthouse, telling them to issue a protective order against me. Again, Rockville Court. Judge Graziani adding the mother to the restraining order. And then last January, he denies his involvement in front of the Judicial Committee at his reappointment. Here you have a judge lying under oath to the Judicial Committee, and they know it. And I guess Judge Steinblum was perhaps the most colorful. I received a call the other night of a person saying, I'm sorry, I'll wrap it up, but he told the defendant that if he wanted his case dismissed, he would stand on the bench and crow like a rooster and he'd dismiss the case. So he did. Or sentencing people to violin, a good note for a good sentence, bad for a bad sentence. And then just to wrap it up, we talked about opening the courthouse. But at Rockville Court, I have 2 judicial complaints that have been sealed and added to my family court folder. They're sealed from the public, so it will bias anyone who reads my court folder. Only judges will see it. And so now they know I have filed complaints against judges. And so it goes on and on, and I've given you the documents. And please review them, and some action needs to be taken, some accountability.
two speakers signed up, I believe, or not, are no longer here. So the next one ready is Francis Nas.
I certainly, as a citizen, appreciate this fact that this commission is formed and that Connecticut does attest to wanting to reform its judicial system. And I think, as we see a lot of the comments here today, there are severe problems with a lot of the procedures and ethics concerning the judges. My original brief here was actually based on rules that would need a change concerning what I have gathered as a producer, giving a serious role in the interest of justice. And I see that to really talk about these rules or any changes would take much longer than 5 minutes. So I'm not going to really deal with them so much tonight as to talk about my own case. I do have a divorce case here in the state of Connecticut. And since that's what people are addressing tonight, that's what I'm going to testify to and submit later documents concerning that case. Now, in my case...
Well, sir, just to reiterate, I did say that we really aren't addressing particular cases, so if you want to express instead what you think this commission should be looking at for its strategic plan, the commission members would certainly appreciate hearing that, since we cannot do anything about your individual case.
Okay, first of all, I think that you have to do all you can to create judges involved in the constitutionality of their rulings. Justice Board was very vocal about this, and as we well know, and there does seem to be a problem, as what I think finding more consistently in my case. In terms of, so I'm just going to go through some of these rules. In terms of legal assistance programs at courthouses, you should use competent employers who know how to construct every motion properly. My experience is that they don't, and that they know what the heck is going on. They understand some of the forms, they can't answer all the questions. As well, there's a notary public that was assigned by the state, and I had to go through a lot of haranguing and deal with the administrative assistant of the courts. To finally tell this notary that he must notarize all documents and not just documents concerning the forms. I think I did actually create that change, so I'm happy to see that it should be written into the rules. I think we have to have a re-examination, especially by the Judicial Review Council, on exactly what misconduct should be. As a matter of fact, I'm following this misconduct issue on a local, state, and national forum concerning the Judicial Conference, on the national forum, dealing with the judiciary committees at both the House and the Senate. And if you want to know more about that, please go online and go to YouTube and look up "In the Interest of Justice," and you will find my testimony conference concerning all those points. But I will have to say that in my case, when I went to the Judicial Review Council and I told them that the Supreme Court panel denied and dismissed my case because they didn't think that my mother being hit by a car was just cause to file a motion late, so the whole thing is dismissed. My family tells me that my mother's going to not live the weekend and that I must leave immediately. I put in a motion to file late, and this was denied. This is an unethical question. This is, as far as the Judicial Review Council is concerned, so what? The judge has discretion. I think we have to re-examine what misconduct is. And I'll talk more. I'll send you more material later about that. There's a whole idea about up at the Appellate Court that these 16 copies is extremely burdensome, especially in this electronic age, where we can provide 1 copy or 3 copies, or even 6 copies, but why does the appellate court need 16 copies that is so burdensome for the average pro se defendant? And especially if we can provide a disk that all the judges and the clerks have access to, and it's online. There's no reason for that these days. Furthermore, understand it's a system that lawyers can submit motions and all sorts of online, all sorts of legal maneuvers online. And I've been asking the court administration for years now, for 3 years, that it's time to make that same access to the pro se defendants. As I say, I didn't even touch a lot of these points, but do read them. And I've submitted them before, but if I had 10 more seconds here, I'd say that writs of error must be returned to the judiciary. These are very important. That strict scrutiny must be abided by. You can't just dismiss a case when strict scrutiny was asked for by the court. To prove that strict scrutiny, under strict scrutiny, it's least restrictive remedy to violating a fundamental right. We need that.
You provided these written comments.
I thank you very much.
Thank you very much. Joe Leslie.
Yes, good evening. Thank you for this opportunity. Judge DiPentima, you yourself have described my case as parties put in court in a very difficult position, maybe an impossible position. The fact that I want my babies back. I'm not going to take lunches here. I'd like to know how many judges sitting in the room. Is that, I'd like to know what the policies and procedures for the Americans with Disabilities Act is. I'd like to know what the notification is that you have. I'd like to know who the trained, designated, responsible employee or ADA coordinator Title 1 or Title 2. I'd like to know what the rate of grievance policy is.
I'm sorry, what?
I'd like to know what the rate of grievance policy is. Any notifications? I'd like to know the definition of disability, why you don't have a definition of disabled compatible with the Americans with Disabilities Act. Title 2 of the Americans with Disabilities Act has been designated or confirmed in Tennessee versus Lane at the U.S. Supreme Court, 14th Amendment protection. We don't have any protection for members of the public. You have a human resource person who, if you search, you're told that you're the ADA coordinator, and that person puts Title 1 barriers in front of you. You must remedy the past, eliminate current, and prohibit future disability and discrimination. I've read your charge, and I don't want to sound angry, but I don't want to sound angry at the committee. But your charge, where are you today, and where are you going tomorrow? Eliminate the past, keep it back in the Buffalo days. Castration, sterilizations, and disabled individuals hidden from society. Lest they nauseate the public, the good people of the community. I've identified 8 barriers to date. You don't have Title II of the Americans with Disabilities Act compliance. This is federal law. Again. Title I, you are covered probably in entirety. I haven't studied that, but when you ask for modifications reasonable for protections, if you get any answer, it's again employment related. And the notification you have is an employment poster, most of them in the employee section of the court. Complacency, you just think that you're under, you're just assuming that you're in compliance. Attitudes, a big umbrella spectrum, color. Ignorance, denial, certain physical accessibility things such as wheelchair ramps, elevators, push button doors, parking places, and direct. So what I'm here to say, I think it gets from anyways, and that didn't happen to me, but certain other individuals. The attorneys, the public, the judges themselves, you have no guidance in this area. Do you have any representatives from the elderly or the disabled communities sitting with you? If you don't fix the disabled and the elderly problems, and you've had notice of that, somebody from an earlier report went out to Reno, Nevada, supposedly, and sat in with the 200 other of your peers back in the early 90s on what you're to get you going on. But if you don't fix, and if I relate this to the school, I heard about, if you don't relate this to what they do in an educational setting, where what's needed by one becomes available to all. And again, related to the wheelchair ramps, I've used it. I don't have a wheelchair. I've carried papers of it, wheel behind me. Pretty much that's it. I go out for days.
Thank you, Mr. Board. David Cummings.
Good evening. My name is David Cummings. In 1984, I suffered a mild traumatic brain injury, and been a lot of things that have transpired as far as accommodating my disability. Many of the acts have been announced from the court reporters. Back in '98, we had Judge Rush in Bridgeport at the time, ordering copies of the audio tapes. And this was done formally. And despite this, many times they weren't complied with it. Still to this day, it still continues. Since 2000, I've requested real-time transcription. And I don't know if this panel, by raising hands, and I don't mean to be disrespectful, if they know what real-time transcription is. Okay. I said not, but I was just saying, okay. Thank you. This has been requested. It's been requested from Chief Clerk Kathy Chase in Rockville Town District. It was made to Judge Ferrazza. They were made to Judge Claysack. For whatever reason, I believe it's Nancy Brown wrote a letter saying that my disability and I wasn't hearing impaired. And they never went to Bob Coffey, Human Resources, for a lot of people here in this room probably heard of Bob. It appears that the procedure for real-time transcription is continuing to be manipulated. As to what is the requirement, how it should be handled, should it be handled by formal motion? In my opinion, it does not have to be ordered by the judge. But in fact,
Judge Hiller, the chief administrative judge, back in December 1st of 06 did order. There was no appeal taken. You would think that would be the end of it, but unfortunately it's not. It was agreed that I would get information on a computer disk, which wasn't provided at that time. I apologize, I didn't prepare a statement. I was actually prepared to come in tonight. It continues. Thereafter, in Talon District, I had a case, and I requested, gave the clerk notice that Judge Hiller ordered real-time transcription. Weeks later, I got a call from Roy Smith, the clerk over on Park Street, that my request has been denied. I'm like, what do you mean? What do you mean it's been denied? I says, it shouldn't. So I said, can you put that in writing? He said, well, I don't know. We'll see what happens at the status conference. So they put it in writing. I requested an extension of time to file reconsideration so I can make a record, despite the fact that no appeal was taken, despite the fact this is not the procedure for real-time transcription. Judge Kaplan denied it the very same day. That's a malice act. So say he wasn't aware of it, which he is well aware of my disability and everything, that he was very clear to allow me to make the record to do that. He denied it the very same day. And as the attorneys on this panel know, that when you get into appellate court, nothing new comes in. That is really sad, okay? So now, what has transpired is I'm on the no-call over in Manchester now. I gave the clerk notice again. I write to Joe D'Alessio. I contact Bob, and said, Bob, I said, my disability isn't something I have to bear in a public courtroom. How do you want to handle it? They continue to try to manipulate what the procedure is. Not Bob says, okay, I want you to go to Joe D'Alessio. I write to Joe D'Alessio. 2 weeks passed. It was like 3 days prior to the hearing. And I still don't get a response. I follow up and he says, oh, well, Kate Nicolay, which is the clerk in Manchester, is going to respond. Most people are not even aware of what real-time transcription is. And it's like, it's not an issue that you have a disability, it's the cause. You know, and that is completely wrong. So, I fire out the letter of Judge Hiller's order, which I complied with to show my disability, the whole 9 yards. The day of the hearing, I get a response letter from, I apologize, Martin Linden, which states, well, that was in Cummings versus Edcon, not this case. So I called him up when I got home. I said, you trying to tell me that I have to retry my disability every time I go into court a lot? He's like, well, I couldn't get a straight answer out of Mr. Linden. Everybody knows Martin's a smart guy. Okay? So this went on. So now, despite this, it's like I write letter after letter. It goes from Bob Crockley to Joe D'Alessio. It's going round and round, but I think it really needs to be clarified that the policy and procedure needs to be posted, because what's happening is the clerks are being allowed to manipulate rulings through this body and not following the proper channels. And where I'm going now with this, because I'm exhausted, is the U.S. Department of Justice is the ones that oversee Title II violations where this is. I apologize, I wasn't prepared. I'm going to follow up with documentation, show everything, and it's really sad, because a lot of times it's just, retaliation, because of discrimination with malice acts by clerks. But I thank you for your time and apologize for my time.
Mr. Cummings, you can certainly give us written testimony.
Well, I think that, Bob Crockley, I respect Bob, and unfortunately, the procedure's being manipulated, so they can't put out, like I asked Martin Linden, I said, do you have something in writing that says it requires the judge to order this? Well, I'll have to look. That's not, it needs to be clarified. Thank you very much.
Thank you. Brian Patterson. Of New London. Is there someone from New London who wanted to speak?
It's a mistake. I did
And Tom from Hartford. If you want to say anything, I can't read your last name. Is there anyone who submitted written testimony? I'm thanking on behalf of the commission members here and the entire commission. Many of the points you've made we